I will note that Miss Churchill has basically prevented the father from being a father since the birth of these children. From her own testimony, she never really let him alone with the kids from birth. She never allowed him to become a father. She never allowed him to learn how to be a father. As noted in a previous finding, the mother has restricted this man's parenting time since his birth. The court will not turn him into a sperm donor. It's not going to happen.
The case that I have for you guys here today is a perfect example of not practicing what you preach. What we have here is a woman who claims that she has a master's degree in marriage and family therapy. And just to prove it to you, let's go down up and take a look. Completing masters in marriage and family therapy, whimsical artist, and event coordinator. Now, while this woman is obviously very educated, knows what she's doing and talking about, she has utilized her understanding of the family court system to alienate her children from their biological father. And the judge is having none of it. To provide therapy to other families, meanwhile you're doing this within your own family, is diabolical work. Let's get active.
In any event, the law basically says it is presumed to be in the best interest of a child to continue a relationship with both parents, and that you each are supposed to have a right to see these children. It's more paramount the children's right to know and get to know the parents, and parenting time must be ordered in a methodology to get that parenting time and the parents to know the children and the children to know the parents. You both have a constitutional right to parenting time and to be a parent. The children have a constitutional right to know, a state right to know both of you. I will note that I reviewed 4 days of hearings, a total of 5.5 hours worth of testimony. There was only one exhibit that was entered. That exhibit were pictures from Mr. Tenhoor of his relationship with the children. The witnesses were Carrie, a preschool teacher, Brittany Churchill, the plaintiff, her mother, I believe it's Robin, now that I can't read my own handwriting, Anthony Tenhoor, and Julie Van Zee, who was the parenting time coordinator. This matter was reviewed in 2022 for a change of parenting time and sent to the front of the court. The front of the court subsequently entered a recommendation on February 6th of 2023, which was timely objected to by plaintiff Brittany Churchill. At that point in time, several hearings have been scheduled and adjourned, and we've held several. The first hearing in this matter was on June 3rd. And we've had several hearings afterwards, some adjourned and some didn't happen, or I don't believe the court adjourned any of them. They were requests by one party or the other. But at this point in time, I'm going to note that I made a mistake in the initial statement. After I reviewed the statute, I indicated that legal custody was on the table. It is not. No one argued for it. No one asked for it. There was no testimony to it. So the court will not touch that. Statutorily, the legal custody stays with the mother. By court order, physical custody is with the mother. And I must find before I make any orders that the custodial environment must be reviewed. At this point in time, the physical custodial environment is with the mother. There is no question as to that, Mr. Tenhoor. And I will get into some reasonings about that. The court does not necessarily have to review any of the 12 best interest factors then, because custody is not in dispute. It's a parenting time dispute. Therefore, the parenting time factors would come into play. I am going to note a couple of the best interest factors, and I'll note why as we proceed. As to the parenting time factors, well, again, there is no clear and convincing evidence and no testimony that would change the physical custodial environment. The existence of any special circumstances or needs of the children, I believe they are vegetarian, but I heard no testimony to say that the father could not handle that. He has had limited time for several months, over 8 months, I believe. I don't believe he's ever had an opportunity to cook for the children, but it's my understanding that is part of his job. He knows how to cook. So I'm assuming he can take care of decent meals for these children and will be given the opportunity to do so.
No hate to the vegetarians out there, but what child chooses to be a vegetarian? My guess is that is the mother's prescription. Let's go.
Therefore, that special circumstance is not a valid reason against him, and it holds to neither party.
Good.
Obviously, mother has been dealing with that issue throughout the children's lives. The children are not of nursing age. We have a 7-year-old and 2 5-year-old identical twins. The likelihood of abuse or neglect of the child during any parenting time, there is no indication.
Good.
Mom had some concerns that the defendant had a DUI, and that was 12 years prior or 12 years ago, long prior to her having children with this man.
Wow.
She didn't have just one child with him, she has 3. So for her to complain that is an issue from the past, her testimony as to his other issues that might be more current, no evidence was submitted other than mom's perceptions of that. Dad denied it during testimony, and it was indicative that I don't have any letters from the employer. I don't have anything stating that this is what happens. And since they have such a stretched relationship, it's hard for me to believe that mom knows so much of dad's life other than her own perceptions of what goes on in his life. So I don't find that there is any likelihood of abuse or neglect by the father in this matter, since we are going on parenting time of the father, not really anything with the mother. I will note that any parenting time standard that is ordered by the court does not affect the custodial environment of the children. But there were no CPS investigations or anything that was presented to the court that have any viability. A reasonable likelihood of abuse of a parent resulting in exercise of parenting time. Again, there is no evidence that there was abuse between the two parties. Disagreements, yes. Not liking each other, yes. Not trusting each other, definitively. I will note that Miss Churchill has basically prevented the father from being a father since the birth of these children. From her own testimony, she never really let him alone with the kids from birth. She never allowed him to become a father. She never allowed him to learn how to be a father. You can't set this up and then blame the other side for its consequences.
Now, not only is this woman bringing up a DUI from 12 years ago, and mind you, again, this is a family therapist, but also you're restricting your children with this dietary restriction to not be fed by their executive chef, biological father.
That's not allowable in the law. You don't get to kill your parents and come to court and blame and throw yourself on the mercy of the court for being an orphan. You can't set him up to say, you're not seeing the kids, I'm not trusting you with the kids, I'm not leaving you with the kids, and then complain that he's not involved in the kids. The fact that he was gone for a year, from testimony, I could kind of understand the frustration of the only time you get to see the kids is if it's under your control, ma'am. That kind of control is going to push somebody away. I'm still not giving him any credibility because he did go away for a year. But still, there was also a year that he was fighting for this and has been, and it's been delayed by the court and by adjournments and by other things. So some of that is everybody's responsibility, not just his. But in that time, he also has gotten married and has children living with him, and there are no CPS reports there. There's no complaint and no testimony that there's any problems there.
By the way, I wonder what it's like going through all of those years of law school, all of the study, all of the hard work, all of the money to defend somebody who is actively trying to break up a family or actively trying to keep the father out of the children's life. Actually, I don't want to. I can't even consider that degree of immorality.
The inconvenience to and burdensome impact or effect of the child traveling to and from parenting time, that is a problem. It is a 55-minute drive. The mother has been taking on all of that transportation. That will no longer be. It's going to be split between the parties. Mom chose to take on that responsibility, so some of it may still be hers, but I'm also making the responsibility of the fathers from here on out. And I'm going to deal with that in how I allocate how the parenting time goes. Whether a parent can reasonably be expected to exercise parenting time in accordance with the court order, I have no doubt that once granted, Mr. Tenhoer will exercise every time that's been granted, unless there is a work emergency or something of that nature. Whether the parent has frequently failed to exercise any reasonable parenting time, I've heard no just walking away from parenting time other than that year that he walked away. So no. I don't find that he would fail to exercise parenting time if granted unless there's an emergency or a work-related problem, of which I would ask that there be a 24-hour notification that I'm sorry I can't make it. Whether the parent is frequently, I just dealt with that one. The threatened or actual detention of the child and the intent to retain or conceal the child. So far, the factors have been pretty well even. This one does go against the mother. The detention is not just the removal of the child or the hiding of the child. It is the restriction of the child. As noted in a previous finding, the mother has restricted this man's parenting time since his birth. The court will not turn him into a sperm donor. It's not going to happen. Continuing his continued supervised parenting time would be an invalidation of laws of the state of Michigan. It is presumed to be in the best interest of these children. He is no danger to these children. You complained at first that he didn't know the children. There are pictures indicating he does. There was a time period he was gone. I will note that he has a home. He has a place for them to be. It is not perfect. Mom has a great place for them to be. I'm not sure who she lives with other than the 3 children. I know that her mother and father are very involved. I don't know if she lives with them or not. There was no testimony as to that. I did meet with the children. I met with them in their individual bedrooms. They are very great children. They are very nice, but the court has grave concerns about how they talk about their father. Really grave concerns. And it goes to a potential interference or just an ability of the mother to not effectuate the father as to being a father.
The term for what the judge is talking about is referred to as poisoning the well, speaking negatively about the father in order to damage the relationship or even just the emotional well-being of those children. Now, this can be very direct, where one parent can just flat out just tell the child that the other parent ain't ish, or it can be covert or very subtle. For example, if you're coming to pick your child up from being with the other parent, you could either be like, hey, so did you have a good time? Or you could be, hey, did you even have a good time? The latter is a subtle way to manipulate the context of the child's understanding. Let's proceed.
Just an ability of the mother to not effectuate the father as to being a father. Some of the things those children said were problematic. There are other words I would prefer to use, but no, they're indicative of a parent that is not facilitating a relationship with the other parent. That violates the inherent rights of the children not to have either parent disparaged by either party or third parties. I am gravely concerned about the ability of the mother to make sure that the father becomes a father. You chose him, not me. And sir, don't complain about her either. You chose her. So I have concerns about her facilitating this, and under the threatened or actual detention, the detention would be the inability to facilitate that relationship. So at this point, I do find that there is no clear and convincing evidence. There is not even a preponderance of the evidence to prevent the father from having normalized parenting time. Now, that doesn't happen automatically. Some judges would just say, look, next weekend he gets every other weekend starting next weekend. We're not going to do that. This court works in the best interest of the children. So let me see if I can move this. I know the father tried to get the children to meet his current wife, which should have easily been done. Again, the warning that was given to you on June 3rd was, you control this or I will have to. I gave you the opportunity, and it's been more than a year, and this should have only taken 6 months.
It's my guess that this man stopped trying for a year because he's dealing with a soul-sucking vampire. It's emotionally draining, and some men just give up. I mean, not only are you dealing with a demon woman that is stopping at nothing to alienate, but then also a court system that assumes that she is the better parent. But it's great to see not only this guy get back in the fight, but also this judge completely dress her down. Fight for y'all children.
So there will be 4 Saturdays with no supervision, although I'm going to alter that just slightly because I've been thinking about this for the past 2 days. My initial note said 4 Saturdays with 2 hours of no supervision. That first time, I'm going to allow the supervisor to be there to help facilitate the meeting of the stepmother with the children, Mr. Tenhor, and possibly the step siblings. These people need to meet. So let's do that first one with the supervisor. Pursuant to Tiedemann versus Tiedemann, the court speaks through its written orders. This is going to take a few days to write that order. This order will begin parenting time of this nature. It'll stay supervised until this parenting time begins by my verbal order, which will take the same effect as a written order pursuant to Tiedemann versus Tiedemann. And that would be the first Saturday will be on the 15th, because I want some time so that the kids are prepared. That first Saturday would be the 2 hours. Mom will drop them off and mom will pick them up for these first 4 Saturdays. The supervisor may be there to help facilitate the meeting of the stepmother and or step siblings. Then there will be 3 Saturdays of 2. Again, mother is driving these first 4 sessions just to see how the 2 hours go. And understand, these children are going to balk. They're not going to do I'm not expecting them to do perfectly. This is a new situation, and a situation in which I think they have no doubt been told will be awful. Then there will be 4 straight Saturdays in a row. So this is 8 Saturdays now. The time will increase to 4 hours. The mother will drop off during those 4 Saturdays. The father will take them to the mother's home at the end of his time. So at the end of 4 hours, so you're going to basically get 3 hours with the children. That last hour will be spent driving the children back to the mother. Okay. And that will be for 4 hours. If I have to, if the parties don't agree, that will be 12 to 4. Then there will be 4 Saturdays of 8 hours, generally 10 to 6. But if the parties agree to other times, that would be perfect. Again, mom will drop off, dad will return. After that first Saturday of 8 hours starts, and here's where the testimony contradicted. I note in the plaintiff's trial brief, she offered Thursdays, but testimony indicates that the children have dance on Thursdays till 6:30. She did testify herself. Her own testimony said that the Tuesdays were reserved for AJ, which I'm assuming is Mr. Tenhor, since those are his initials. So he will have Tuesdays at 5, where mom will drop them off, and he will have them back to her by 7:30. Sorry, it's only an hour and a half, but unless you move closer and the kids have a bedtime, I'm stretching it a little bit because their bedtime's at 7:30. So I'm taking that into account, but at the same time, I'm trying to give some time here during the week because I don't want parents going over 2 weeks without seeing the kids. After those 4 weeks are over and the Tuesdays begin, the Tuesdays will stay a constant. After those 4 weeks are over, you'll start every other Saturday for 10 hours and and that's next Sunday for 10 hours. What we're trying to set them up for is the every other weekend, because that's where this is going. And that'll occur for 4 times, so that'll take 8 weeks to get over. All right, so that's 10 hours. Then it'll be, after those 4 weeks are taken care of, then it will be the 5th weekend after that will be Saturday at 10 until Sunday at 7 p.m. That'll be the first set of overnights. That will go for 4 times. So it'll be 8 weeks.
It's my suggestion to this brother right here to really do a fantastic job of documenting everything going forward, because I do believe that her having primary custody is always going to be a thorn in his side in the completion or the mending of the relationship of his children, the lost time. I think it's clear that her hate for him is so prioritized that she will stop at nothing to make his life a living hell. Just wait, Mom, until your kids get older and they realize that you did everything in your power to poison the well and to keep their biological father away from them. Just wait for them. A family therapist doing this to her own family. What a monster.
Then, after those 4 times are done, it'll be every other weekend, Friday at 6 until Sunday at 7. Again, mother will drop off to the father's house. Dad will return the children to her house at the end of his parenting time. At that point in time, so this should be about Thanksgiving. Since the father has never had a holiday, we're going to start with, Thanksgiving to the father. I will send you, Mr. Crow, I think your office has my holiday time schedule. I will email it to you in a Word format. That way you can just incorporate it and it will line up. Now, spring break one way or the other, I'm going to have to adjust this. So we're going to have to work on, because it's supposed to be every other holiday. Spring break for 2025 will be with mother. The summer of 2025, dad will have 3 full weeks, his weekend plus 5 days with the children for vacations. Mom will also have 3 full weeks. Dad is to send mom his 3 chosen weeks by April 1st. That way, if there's a disparity or a discrepancy, somebody may file a motion to confirm or deny that. Mom also gets to then choose her 3 weeks. Normally, preference will be given to the father in odd years of the 3 weeks. Preference will be given to the mother for her 3 weeks during the even years. Because sometimes things occur and people plan things out a year in advance. I am not dealing with child support. There was no testimony as to that. I believe Mr. Crow started down that road, but child support was not in contest here. And since I'm only granting approximately 70 or so overnights, parenting time does not affect child support in any event. Child support can be reviewed if there's a change of income for either party or after 3 years. Since this order was entered into, I believe, in 2022, it may be reviewed early in 2025 again. That takes care of parenting time, the issues before the court. Mr. Crow, any questions?
I don't have any questions regarding the court's decision, Judge. Thank you.
No problem. All righty. And we'll
Wow.
try and get through that on a thumb drive if possible for you to review. That way you may type up the order. Mr. Tenhor, any questions?
Is Father's Day and Christmas and all that, that'll be in the
That will be part of
FSD.
that will be part of the holiday time. That probably won't start just yet because we're starting the parenting time slowly over time.
You can already see the way that she's mouthing to her lawyer, save me, please, do something. It's worked every other time before. You could just see the anger strewn, the bitterness strewn across her face. She's so upset that he's moved along. He's in another relationship. I believe that he's married right now.
Okay.
All right, that's for the benefit of the children, not for you. Like I said, there are some judges that throw the kids straight into every other weekend and start all that. I don't want to traumatize the children that much. I think there's more they need to get used to.
Yep, I
I
understand.
think once they get used to you and get acclimated to your environment, they will be fine. You can expect them to balk a little bit, Ms. Tenhor. Sorry,
Yeah.
but you know, I have other comments that I will make that I will reserve if necessary for any future hearings.
I don't
So
have any.
I'm trying to make sure that I keep the parties on an even keel and that we move this along in accordance with the law. Like I said, the law has stated, and I told you this in the first place, parenting time is presumed.
And there you have it. I'm so happy that this judge took a stand towards all of this BS, because I'll tell you guys, I get a little bit scared when I see men in here without a lawyer present, especially if the ex-wife has her lawyer present. But yeah, totally insane. A family therapist that's utilizing 12-year ago DUI, one of which she had children with him after that. Like, why would you keep on having children with somebody who you really think would be a danger to the already born child if you really thought that that was a issue? But what's scary is that there are actually would-be judges that would hear that and would agree with her. But that has been your video for today. Guys, drop me some comments down below. What did you think about the court case here today? Let's have a conversation about it. Last but not least, I got a men's self-development community. Link to it down in the description box down below. Yo, the knowledge up there, you understand me? We going completely in, and especially if you have a focus on becoming wealthy, your financial fitness, this is the community for you. We're sharing all the tips and all the gems up there, all right? Until next time, YouTube.